চশমা দেবো না। মানে in this case, father was alive. He is alive, my lord. Do it is shown in the, my lord, evidence, my lord, this is his father. That day, your lordship asked me whether father was alive or not. He is alive, my lord. So he has given evidence, my lord, in this case. Oh, yes. It is typographical mistake, my lord.
Please take your seat.
Tiene de una ilustración que tiene buenas ilustraciones. Dice, luz o la razón, la justicia, ¿no? Peki şey falan ya. Peki. Ha, değil sanki ben. no? No, eight. No.
Yes, madam, please state your case.
His father was my lord, before the,
Kindly read your written statement.
yes, my lord.
At page,
Page 24, my lord.
page 24. Yes. Read very slowly.
Yes, my lord. That the above case is not maintainable both in law and facts. that the opposite party is neither a foreigner nor an illegal migrant as alleged, that the case is filed against the opposite party physically without any proper verification, that the opposite party is a citizen of India by birth. Her deceased father's name is Gajendranath Sarkar. He was born and brought up at village Moishapara, Part 1, P.O. Agamoni, P.S. Agamoni district, Dhuburi, Assam. The opposite party was married with one Sukumar Roy, son of late Raman Roy, village Kaldoba, Part 1, P.O. and P.S. Agamoni district, Dhuburi, Assam. And opposite party is presently living with her husband in the aforesaid locality. That the opposite party grandfather's name is Radha Raman Sarkar Biswas is recorded with her NRC details in village Moisa, district Golpara, Assam. The opposite party's grandfather's name is appeared in the voter list of 1966 under 35 Gulogans LAC at village West Moisa, Part 2, P.O. Agamoni, P.S. Gulogans subdivision, Dhuburi in the district of Golpara, Assam. Height serial number 20, house number 10. A copy of the voter list 66 annex. That the opposite party's grandfather name is appeared in the voter list 1970 under 35 Gulogans LOC, village West Moisapara, Part 2, P.O. Agamoni, P.S. Gulogans subdivision, Dhuburi in the district of Golpara, Assam. Serial number 22, house number 7. Photocopy of the certified voter list annexed here. The opposite party's grandfather's name is appeared in the voter list 1985 under 25 Gulogans, West Moisapara, Part 2, P.O. Agamoni, Gulogans subdivision, Dhuburi in the district of Dhuburi, Assam. Height serial number 112, house number 47. That the opposite party is born and brought up village Moisa and has obtained a birth certificate in her name from Halakura PHC, and she was born 10/2/1994, issued by the Birth and Deaths Department. A photocopy is enclosed. That the opposite parties and forefathers is a by birth India, and she never casted her vote at anywhere due to her age was below 18 years before her marriage, and after her marriage, when she went to enroll her name, the authority recorded her name as a D voter. That the opposite party's father, Gajendranath Sarkar, a son of Radha Raman Sarkar Biswas, Radha Raman Sarkar, has a family identity card of serial number 609787. A photocopy of the identity card is also annexed. The opposite party's father's name recorded as Gajen Sarkar in the family identity card, and Gajendranath Sarkar recorded as linkage certificate, birth certificate, and her grandfather name recorded as NRC details, Radha Mohan Sarkar Biswas in the NRC details, but the voter list from 1966 to 85 recorded as Radha Raman Sarkar. That the Gajendranath Sarkar is the own identical person, that is opposite father, and Radha Mohan Sarkar and Radha Mohan Sarkar Biswas, the one identity person, her grandfather, none else. That the opposite party and her father, along with her grandfather, never migrated from anywhere or any foreign country. They are the by birth Indian citizen. That before my marriage, I recorded my name as Monomuti Sarkar, but after marriage with one Sukumar Roy, I have taken my husband's surname Roy. Hence, my name recorded from Monomuti Sarkar to Monomuti Roy, and Monomuti Sarkar and Monomuti Roy is one identical person, that is myself. That the Foreigner Act 9 is not maintainable, opposite party, provision of 25 March 1971.
Now please read your affidavit in evidence.
Affidavit. I, Monomuti Roy, aged about 22 years, wife of Sukumar Roy, Gajendranath Sarkar, resident village Moisa, Part 1, POPS, Agamoni district, Dhuburi, do hereby solemnly affirm and declare on oath as follows: that I am the opposite party in the instant case, fight FT case number, FT court at Dhuburi, and permanent residence of above mentioned locality. That the Union of India has filed this case against me without proper verification. I have sufficient documents to prove me as Indian citizen. That I was born and brought up at the Khaldoba, Part 1, PO Agomani, PS Agomani Duburi. My father's name is Gajendranath Sarkar, Ambarsa Sarkar. That at the time of puberty, I was married with one Sukumar Roy, son of Ramesh Roy, resident village Moisa, Agomani district Dhuburi. Then I was born 10/2/94 at Khaldoba Part 1. In this regards, one birth certificate issued in my name from Halahura PHC issued by birth and death department. That in some relevant papers, documents of my father's name has been recorded as Gajen Sarkar. Some other relevant papers, my father's name has been recorded as Gajendranath Sarkar. Both the name Gajendra and Gajendranath Sarkar indicated same and one identical person, that my father. That in some relevant papers and documents, my grandfather's name has been recorded as Radharaman Sarkar, Vishwas Radharaman Sarkar, respectively. All the names are indicated same and one identical person. That is my grandfather. My grandfather's name is Radharaman Sarkar. My grandmother's name is Rangamala Sarkar, and my father's name Gajendranath Sarkar. Name were enlisted in the voter list 1966. File serial number 20, 21, 22 respectively, and house number 10, village 102, Paschim Moisha Part 2, under 35, Gulokganj LOC. The voter list 1966 certified copy is annexed here with. My grandfather's name has been recorded in NRC details, Moisa, and also my grandfather's name has been recorded in the certificate of registration 1950, which is issued by the Deputy Commissioner, Gwalpara. That my father's name has been recorded in the caste certificate issued by the Office of the Chairman, District Scheduled Caste Development Board. That my grandfather's name enlisted in the voter list of 1970 under 35 Gulokganj LOC 22, house number 7, and village West Moisapara Part 2. That my grandfather's name was also enlisted in the voter list 1985 Gulokganj West Moisa Part 2. That my father's name has been recorded in a family identity card by serial number 609787. That I am the citizen by birth, and I am neither a foreigner nor I ever came from any other country, and thus I would be protected by the Indian Constitution as a bona fide citizen. That I have already submitted all the relevant documents along with the written statement before this honorable tribunal. That I prayed for dismissal of the case, declaring me as a citizen of India in the interest of justice.
So according to you, your name, the name of your father is Gajendranath Sarkar,
Yes, my lord.
and
Gajendra, Jogendra.
listen, your father name is Gajendranath Sarkar as per your records.
Yes, my lord. Yes, no, actually Gajendra.
And
Somewhere Gajendra, somewhere it is to
okay,
Jogendra, my lord.
so as per your
Both
written
are same
statement,
person.
name of your deceased father is Gajendranath Sarkar,
He's not disease, my lord. It is typographical mistake, my lord.
and born and brought up at village Maisa Part 1 under Agomani Police Station at India district of Dhubri. So according to you, your deceased father name is Gajendranath Sarkar. Listen very carefully.
Yes,
your
ma'am.
seat, take your seat. When you will be asking you, then you just reply.
Yes.
So as per this written statement, name of your deceased father is Gajendranath Sarkar. You have been born and brought up at village Maisa Part 1 under Agomani Police Station in the district of Dhubri. On attaining puberty, got married to one Sukumar Roy, who is also from village Khaldoba Part 1, Agomani. Your projected grandfather, Radharaman Sarkar Biswas, name was recorded in the NRC details at village Maisa in the district of Gwalpara. Name of your grandfather appeared in the voter list of 1966 pertaining to 35 number 35 Gulokganj Legislative Assembly constituency at village West Maisa, Part 2, under Agoboni Police Post Office, Golokganj Police Station, District Dhubri. Name of your grandfather again appeared in the voter list of 1970, the same constituency at village West Maisa, Chor, Part 2. Father, name of your grandfather appeared in the voter list of 1985, Golokganj constituency at village West Maisa, Chor, Part 2. You said that you have been born and brought up at village Maisa, and you have obtained a birth certificate in your name from Halakura Public Health Center on 10th of February 1994. Sorry, showing that your date of birth is 10th of February 1994. Your name was not enrolled earlier because you were less than 18 years. And when your name you want to enroll your name in the voter list, you have been recorded as D voter. According to you, your projected father, Gojen Sarkar, alias Gajendranath Sarkar, son of Radharaman, alias Radharaman Sarkar Biswas, alias Radharaman Sarkar, and who has a family identity card. According to you, the linkage certificate is your birth certificate. Name of your grandfather recorded in the NRC details, as well as in the voter list from 1966 to 1985. Then you have said the Gojen Sarkar, Gajendranath Sarkar is the same in one person. You have also stated that your father, along with your grandfather, never migrated from anywhere in any foreign country. That is your written statement.
Yes, madam.
Now, in your affidavit in evidence, you say that you are a resident of village Moisa, Part 1, under Post Office and Police Station, Agomoni. In the said affidavit, at Parachi, you say you were born and brought up at Kalduba, Part 1.
After my
Whereas,
receiver.
in your written statement, you have said that you've been born and brought up at village Maisa, Part 1.
Doesn't mean that she was foreign. Is a foreign.
In your affidavit in evidence, you have said that name of your father is Gajendranath Sarkar. Name of your mother is Omborsa Sarkar.
Anjana Bala Sarkar bola hai, jata likhe.
Then,
This is for the
after marriage, you are living with your husband in the village Moisa, Part 1. There is a marriage link certificate issued by the Secretary of the Agoboni Gaon Panchayat, which is Exhibit 1. You were born on 10th of February 1994 at Kalduba, Part 1. And in that regard, you have received or you have obtained a birth certificate. Your third exhibit is the photocopy of voter list of 1966, where your projected grandfather, grandmother, and name of your father were enlisted. Your exhibit 4 is the photocopy NRC details of your grandfather. You said that your name of your projected father was recorded in the caste certificate issued by the office of the chairman of the Scheduled Caste Development Board. From the records, what we have seen, your first exhibit is your Gaon certificate issued by the Gaon Panchayat Secretary. Which you have not annexed here. Might be you might be having a copy of that. You have not annexed your that particular certificate in your writ petition.
কোনখন?
Your first exhibit
Exhibit, yes, my lord.
is your certificate issued by the Secretary of Agowani Gaon
Yes, my
Panchayat,
lord.
where it is clearly written that Monomoti Sarkar, daughter of Gajendranath Sarkar and Anjana Bala Sarkar, resident of Kalduba Part 1.
Yes, my lord. Name is shown different. Somewhere
Aged about
part one.
18 years, was a resident within this jurisdiction of this Gaon Panchayat. And Monomoti Sarkar got married on 2nd of July 2013 to Sukumar Roy. That is your exhibit 1. And this document was not proved
Yes, my lord, not proved.
by any issuing authority. Second is your birth certificate. That is your linkage. Both this Gaon Panchayat Secretary's document
Yes, my lord.
as well as
And
your birth certificate as a linkage with your
linkage.
father. Now here, this birth certificate was issued on 8th of June 2015
15.
with the remark second issue.
Yes, duplicate.
We do not know whether the second issue is duplicate or not. Here, it is clear Monomoti Sarkar, female, date of birth 10th of February 1994, resident, place of birth is Maisa Part 1. Mother is Anjana Bala Sarkar, father is Gajendranath Sarkar. There is some overrating anyway, Gajendranath Sarkar.
No,
At the time of
operating now.
birth of the child, resident of Maisa Part
2.
Here it is 2.
Yes.
Permanent address of parents, village Maisa Part 2. Exhibit 3, 66, voter list of one Radharaman Sarkar, Rangomala Sarkar and Jogendranath Sarkar. Jogendranath Sarkar, son of Haridatta. Next exhibit which you have placed before the tribunal is registration certificate 1 of Radha Raman Sarkar.
Sarkar, yes. Wife is Anjana Sarkar, it is shown.
Then exhibit 5, caste certificate issued in the name of Gajendranath Sarkar, son of Radha Raman Sarkar of village Maisa Part 2.
ওখানে বেশ বেয়া হয় দেই ডিফারেন্ট ভালকে হেৰি কৰিব লাগে সমান কৰাব
Then
লাগে
exhibit 6 is the
নাজানি
electoral photo identity card of one Gajendranath Sarkar, son of Radha Raman. village Kalduba,
Decision person he get a level again. Shooting photo, I'm just actually 18 point of
now
shooting photo different
all your exhibits,
shooting photo different
you have deferred from your written statement. You have clearly stated that you are a resident of born and brought up at Maisha Part 1 in your written statement, whereas in the affidavit in evidence you said Kalduba. Whereas the voter card of your protected father is from village Kalduba. The voter list that you have placed before the court, before the tribunal, relates to village Maisha Part 2, not even Maisha Part 1.
Somewhere Maisha Part 2, somewhere Maisha.
So it is the procedure under section 9 of the Foreigners Act is required to prove his or her citizenship, right? That she is not a foreigner. From these material before the tribunal, how can you say that the tribunal was wrong in passing that order?
But in this case, my lord, some documents were not proved, my lord. So my humble submission, let the matter be placed
What?
for two, since it was not, legal documents is not examined by the,
Which legal document was not examined?
yes, lordship kindly peruse the judgment, my lord.
Yes. Kindly read.
That para 6, my opposite party has produced and exhibited some documents to substantiate her aforesaid statement. Let me analyze those documents along with the evidence on record to determine the nationality status. Opposite party has exhibited a birth certificate, exhibit 2, issued by the concerned authority in the year 2015, where opposite party Monomoti Sarkar's death certificate has been recorded as 10/2/94, and her parents' address is recorded Moishapara Part 2, and her parents' name is recorded as Gajendra Sarkar and Anjana Bala Sarkar. The said birth certificate has been issued by the registered of birth and date Halakura PHC in the year 2005 for the second time, but nowhere in the certificate it is recorded as duplicate copy. The date of issue of the said certificate has been recorded as 17/2/1994. In her WS, he stated she would and brought up at the village Maisapara Part 1, para 4 of the WS. But in para 9 of the WS, opposite party has stated that she was born and brought up at Kalduba Part 1, Agamoni district, Dhuburi, and her father's name is Gajendra Nath Sarkar and mother's name is Ama Borsa Sarkar. In para 5 of the affidavit, opposite party has stated that she was born in 10/2/94 and from the Halakura PHC. In the said birth certificate, opposite party projected mother's name is recorded as Amar Brasa Sarkar. The aforesaid contradictory statement made in WS and affidavit raised serious doubt regarding the authenticity of the said village Moishapara Part 2. In her cross-examination, opposite party has deposed that she is an ignorant as 17/2/1994, and the said certificate has been issued for the second time in the year second time. As per rule, the remarks column, the cause of the second issue should be recorded. Hence, exhibit 2 is rejected as genuine piece of evidence. Opposite party has exhibited a certificate dated 10/7/2015 issued by the secretary Agamoni Gaon Panchayat, which is countersigned by the block development officer. Agamoni Dev block, where opposite party parents' name have been recorded as Gajendra Nath Sarkar and Anjana Sarkar, mother of Kalduba Part 1 under Agamoni Gaon Panchayat district Dhuburi. It is specifically mentioned here in that as per Honorable Court's order dated 28/2/2007 passed in WBC 2364/2016, The aforesaid certificate has no statutory sanctity. It would be based private documents, and as such, as per evidence, the said document must be proved by the issuing authority. Yes, my lord. In this documents must be proved by the issuing authority. In this case, the said certificate has not been proved by the issuing authority. Hence, the said certificate is rejected as a piece of evidence. That Panchayat office of the Secretary Gaon Agamani Gaon Panchayat, my lord, it was not proved, my lord. And lordships. In this case, the said certificate has not been proved by the issuing authority. Hence, the said certificate Exhibit 1 is rejected as a piece of evidence. It is pertinent to mention here in the said certificate, opposite party parents' address is recorded as Kaldova Part 1. Opposite party has exhibited some documents claiming to be her grandparents, and for father's documents is Exhibit 4, Exhibit 5, Exhibit 6, Exhibit 567, Exhibit 568. As opposite party has failed to establish her linkage with her projected father, Gajendranath Sarkar, the aforesaid documents are not at all conducive to prove the nationality status opposite party Manumati Roy. Nevertheless, for the ends of justice, I am going to analyze those documents in a nutshell. Opposite party has exhibited the certified copy of voter list 1966, Exhibit 3, as per her statement made in paragraph 8 of the affidavit. Her grandfather's name is Radha Raman Sarkar, grandmother's name is Rangamala Sarkar, and her father's name is Gajendranath Sarkar, has been recorded in the voter list 1966 at village 102, Paschim Moisa, Part 2, under 35 Gulagons LOC. On perusal of the Exhibit 3, it is seen that opposite party projected father's name is recorded as a Gajendranath Sarkar, son of Harit Datta, which is contrary to the statement made in para 8 of the affidavit. Nowhere in her WS affidavit has stated that in the voter list 1966, her father's name is wrongly recorded as Gajendranath Sarkar and her grandfather's name is wrongly recorded as Harit Datta. Therefore, a genuine and serious doubt in the absence of the available reliable documents or explanation on record arises. As such, the said documents cannot be acted upon the trustworthy piece of evidence. Opposite party has exhibits the certified copy of the voter list 1970, where in also one Jogendranath Sarkar's name has been recorded at village 102, West Moisa, under 35 Gulagons LOC, height serial number 24. And the said Gajendranath Sarkar's father's name is where Haridatta Haridas is not clear because of overwriting. Nevertheless, this document is also rejected as a piece of evidence because the overall analysis of the other document Exhibit 2 and 3, as opposite party has failed to establish her linkage with her project grandfather Radha Raman Sarkar, Exhibit 4 cannot be accepted as the documents of her real grandfather. Hence, the said documents cannot be relied upon. Exhibit 5, 6, and 8 as are post 1971 documents. Opposite party projected father with whom opposite party could not establish her linkage, which cannot in any help opposite party to establish evidence. Thus, in the absence of the documents and oral evidence at Gajendranath Sarkar, Gajen Sarkar is the father of the opposite party. The document exhibit by the opposite party Radharaman Sarkar, projected father, cannot be relied upon as the opposite party has failed to establish linkage with her father. Therefore, for the reasons and discussed above, it appears that opposite party has taken the help of some false and manipulated documents to prove itself as an Indian national. Hence, I am of the considered opinion that opposite party Manumati Roy has miserably failed to discharge her burden to prove that she is a citizen of India. To sum up, opposite party has miserably failed to discharge her burden to prove that she is not a foreigner. For the reasons and discussed above, the evidence and documents filed by the opposite party in support of her person are found to be contradictory, not sufficient and trustworthy to prove that she is a citizen of India by birth through genuine Indian parents. Rather, it appears that opposite party entered Assam without authority. Subsequent to 1971, and hence she is termed to be foreign post 1971 stream, and she is entered Assam on or after 25/3/1971. Well, I am placing that documents which was not approved by the tribunal, my lord.
Which one?
That is, my lord, Panchayat Secretary Agamani Gaon Panchayat,
Now have-
where her name is shown as a Monomuti Sarkar, my lord. Father's name also shown as Gajendranath Sarkar. And regarding, my lord, they were actually very poor and they were uneducated, my lord.
That is,
And there is a order passed by this honorable court also. The name of the anomalies of the name or place, my lord. Actually, I was born, my lord. I am born at Julpukhuri, but I have always written at Dighalipukhuri, my lord, in my address before my marriage, my lord. Now I am in Ujjan Bazar, of course.
see,
That is the point, my lord. But my mother always written from Julpukhuri. Address was always shown as Julpukhuri. That is the point, my lord. Actually, it is not a hard and fast. There is no hard that she was not born in India, actually, my lord.
Okay.
And father also stated himself that Monomuti Roy is the her daughter, my lord.
it is whose duty to prove before the tribunal
Of course, my lord. That is the point, my lord.
by reading these documents that you have, that the proceeding have exhibited. Do you think that she could sufficiently prove?
And my lord, it is shown that this is father also like that. Yes,
Tell us,
my
where
lord.
is the
Yes.
illegality in this?
That is my point, my lord. Since
See,
it was
the-
not
whatever
exhibit.
Whatever was placed before the tribunal, tribunal has accepted everything. You may not be aware, but it is available on record at a subsequent stage. The proceeding, because in her affidavit in evidence, she has only exhibited 6 documents. Later, by filing an application, she produced 2 further documents, that is voter list of 1966 and voter list of 1970. Certified copy.
All are shown actually, but
What was not considered, because in your affidavit in
considered
evidence,
means yes, my lord. There is a
They are only up
discrepancy
to-
between father and daughter.
we are only up to exhibit 6.
Hmm.
But in the judgment, you might have noticed there is mention of exhibit 7 and 8. Now the proceeding file an additional affidavit that was accepted. And that's how the proceeding could place before the tribunal the certified copy of voter list of 1966 and 1970. In the year 1966, sorry, in 1970, instead of Hori Datta, something there was overwritten, it is Hori Das. That's what been mentioned by the tribunal.
My lord, in
Yes, to-
2015, my lord, NOC 77, it is, my lord, it is shown that it is a common phenomena in rural area, more particularly among Muslim community to have more than one name, and
That's
thus,
not on that.
that's, yes, my lord.
That's the question
discrepancy.
of Muslim.
There is a,
not there.
no, there is a discrepancy, I want to say, my lord. Discrepancy in the name of the name of the place and name of the, because part 1 and part 2 is nearby, my lord.
Hmm.
But district was Dhuburi, my lord.
For
That is the
first
point,
time-
because in birth certificate also, your lordship shown that Gajendra and Anjana, my lord.
Now
But
it's-
it was not proved by the tribunal, my lord. It should be proved, my lord.
By whom? By the tribunal?
No, my lord, by the advocate of the respondent, yes, my lord.
Proceeding have
And
to-
she also stated that it was not proved. It is a evidence, my lord, genuine evidence,
Both the voter list of 1966 and 1970,
because under evidence check, it should be proved, my lord.
along with Ravaraha Raman Sarkar and others, there is a name of Jogendranath Sarkar. It is not the case of the proceeding that Gajendranath Sarkar and Jogendranath Sarkar is the same in one person. It is the case of the proceeding, the Gajen Sarkar, Gajendranath Sarkar, and Gajendra Sarkar is the same in one person. Only in the name, The name of the father of the.
For discrepancy of the name, lordships, it is not that she is not a Indian, my lord.
Why?
Because, my lord, they are illiterate, and it is it is shown also that because they are very poor and illiterate, and they were actually not, they have no knowledge actually
Also
about.
was that evidence has clarified that if a person is poor, illiterate,
Apparently, my lord,
in
if
that
your lordship,
case, her case should be considered or his case should be considered as an Indian citizen.
no, my lord, apparently, my lord, it is shown that she is Indian, my lord. Though it is conduct of the case is
Where from your,
not.
which document shows that she is an Indian?
My lord, that is, my lord, office of the Agomani Secretary, Agomani Gaon Panchayat also issued, and then death certificate, birth certificate also issued,
Right.
my lord. Both the names are same.
Whether that certificate issued by the Gaon Panchayat has been proved by you.
Yes, my lord, that is the point. That's why my humble submission, lordship, kindly remand back to the on the
That prayer should have been made before the tribunal. After filing your.
lack
affidavit
of the,
evidence.
my lord, lack of the knowledge of the advocate, my lord,
Evidence of
petitioner
that
should
you
not be suffer, my lord.
So us, while exercising the power under Article 226, exercising power under certiorari, we can.
My lord, I need let the matter be listed Friday, my lord. I need.
No further since already you have heard you second time in the same issue. Last week you have heard.
Yes, my lord, last week,
have also
because
heard.
of that, my lord, disease father and all. But he is not a disease, my lord, he is alive, my lord.
It is your affidavit, right? Your.
Yes, yes, my lord, that is right. মানে they না
Yes, who is appearing?
যিকো ক আৰু মই কি কম ভাই একদম ভাল কেছটো বেয়া কৰি পেলালে
May I please, madam? Madam, as your lordship has pointed out, and it is clear, my lord, there are enough contradictions with regard to the, my lord, the entered facts, the date of birth, place of birth. In fact, my lord, the first, your lordship may kindly see one important thing, that is the evidence of DW2.
There is no evidence of DW2.
Yes. Oh, that was not placed, madam. But here it is
In the
annexed.
writ petition, it has been annexed.
It is annexed in the writ petition.
There is nothing,
Yes.
nothing is available in the records. There is no mention in the order sheet.
Yes, ma'am. But even though, my lord, there is
Yes.
the writ petitioner in WS, my lord. The lordship may kindly see. In WS, he has said, rightly, my lord, in WS, she has said, my lord, in WS, page 24, my lord, the opposite party is a citizen of India by birth, and her deceased father's name is Gajendranath Sarkar. She was brought up at village Mosaipara, part 1. That is specific, madam. That is specific. And in evidence, my lord, page 29. Page 29, my lord, it is the evidence of the petitioner. It is in para 3, my lord. Another specific statement here in evidence. I was born and brought up at Kolluba, part 1. So this is not Mosaipara part 1 or Mosaipara part 2, my lord. This is totally two different places. It is their evidence, my lord. It is, and contradiction in the date of birth, place of birth, which is an important issue here, my lord, because for determining the citizenship. Then, my lord, if we believe, my lord, I'm not going to say anything more, my lord. Annex page 12, this is the birth certificate. If this birth certificate is correct, the statement in evidence cannot be correct, because here the place of birth is shown as Mosaipara part 2. Mosaipara part 2. So the law is well settled, my lord. When the person himself, because it is the person concerned who knows everything, my lord. The comment cannot, but the prosecution, the government cannot know my lord, where the date of birth or place of birth of the petitioner is. It is the petitioner himself who knows all this. This is the personal knowledge of the petitioner. It has to be stated clearly, my lord. If he himself or she himself, herself is not clear about her place of birth, date of birth, my lord, we cannot presume, the tribunal cannot presume that his place of birth is this or his place of date of birth is this, my lord. So tribunal cannot, my lord, presume what is not pleaded in the, my lord, what is which are contradiction, which are contradictory by itself in the WSM written statement. The voter, now, my lord, the petitioner is relying on the voter list of 1966. 1966 voter list is of Radha Mohan Sarkar, Rangamala Sarkar, Jugendranath Sarkar. Why I was relying that evidence? Because my learned senior friend was placing that, my lord. The evidence there, this, my lord, the Gajendranath Sarkar has said he is the same in one person as Jugendranath Sarkar. It cannot be correct. Because here the date of it's a, my lord, the father name is Haridatta. Jugendranath Sarkar, his father name is Haridatta, and his age was 40 years in 1966. So his date of birth will be sometime in 1926. But if it is the same person, my lord, your lordship may kindly see that is page, my lord, 85 voter list of page 17. Here it is Gajendranath Sarkar. One Gajendranath Sarkar is there. He is son of Radharman, and his age was 32 years in 1985. Jugendranath Sarkar and Gajendranath Sarkar cannot be the same person, as the father name is different here, and the age is also decreasing from 1966 to 85. It should have been increased, but it is decreased. And if it is his date of birth, his age was 32 years in 1985. His date of birth will be sometime in 1953. So 1926 and 53, it's a huge difference, right? So it cannot be the same person. The petitioner is trying to project this, my lord, Jugendranath Sarkar, but yes, in fact, neither in WS nor in my lord, the evidence. He has stated that Jugendranath Sarkar is his and Gajendranath Sarkar is same person. To that effect, my lord, we may leave that aside. Now, my lord, the petitioner to link herself to this Radha Mohan Sarkar. In fact, the 1965, it is Radha Raman Sarkar, and she is trying to project herself to the granddaughter of this Radha Raman Sarkar. And now, what is the link documents, madam? Link documents, as your lordship has rightly find out, two documents. One is a school certificate, not proof. And the Panchayat certificate, it is not proof. And the birth certificate, my lord, birth certificate contradictory itself. What is stated in the, my lord, WS as well as evidence, and being not proof, this cannot be accepted as a piece of documentary evidence for the purpose of, my lord, citizenship. Now, as my learned senior friend is, my lord, saying that this matter may be remanded for the purpose of, my lord, proof of these two documents, birth certificate and the, my lord, Panchayat certificate. My lord, the Panchayat certificate and birth certificate, these are produced by him or produced by her, my lord. It is her duty to prove her case in the tribunal, my lord. It is the duty of the petitioner proceeding to bring the evidences before the tribunal, and there is no fault on the part of the, my lord, the tribunal or respondents. So now, as these documents were not proved, it cannot be said that it may be remanded. She fails to prove this her case before the tribunal, and this is, my lord, as I have
for
argued,
ends of justice, my lord,
my lord, ends of justice to that
yes,
effect, my lord.
Because due to poor conduct by the advocate for the learned tribunal, my lord.
This honorable court has considered all these things in the numbers of cases, my lord. Ends of justice cannot be, my lord, go down to a particular site. It should be considered in their respect. So unless is something these to do, because Section 9 has provided, madam, it is their duty to prove whatever they brings into the evidence. The statement in the WS is different. In fact, the evidence is different.
Too many cases has been remanded, my lord, by this honorable court because of that, my lord. Was not proved by the Planet Tribunal, my lord, at the time of hearing, my lord, at the time of proceeding, my lord. So let her give him one chance, give her one chance, my lord.
We would have loved to give her one chance. If she would have stated in her written statement
Yes, madam, that is correct.
correctly, or in her any evidence in affidavit correctly.
No, I am not on that, my lord, I am on that,
That is the
yes,
reason
my lord.
we cannot allow you to adduce fresh evidence. But your affidavit in evidence, the relevant exhibits, and your written statement doesn't tally at all. So question of giving you chance doesn't arise here.
Dismiss. Hey, him and say. Photo.
On 8th of December 2016, petitioner wanted to adduce evidence of one DW2. It is in record, that's the reason we are letting you know. But who is DW2? Not been specified. So tribunal on 8/12/2016 rejected the prayer of the proceeding. Thereafter, the proceeding filed another application on 21st of December 2016. Since her application of 8th of December 2016 was rejected on 8th of December itself, so the court did not accept her application she filed on 21st of December 2016 regarding the affidavit in evidence filed by the DW2. These things you have not stated in your petition, nor you are accepting this annexer at page 33. Fine.
The certificate shown that my lord Gajendranath Sarkar is a son of my lord Radha Mohan Sarkar. Part 2 হ'ব লাগে তাৰমানে কি কৈছে ঠিক কৈছে জানো এই অফিসে ইজে কৰে কেনেকে মাৰে এইখানে ডিজিজ ফাদাৰ লিখিছে ওকিলত আছে ভালকে চাইছিলে কিন্তু হা No, পিছত দিছে পিছত মই বাপেকে statement দিছে সেইখিনিতো দিয়ে আছে কিন্তু কেছটো ভাল আছিলে জানা গোটেই বেয়া কৰি দিলে আৰু এবাৰ ক'ৰবাত পাতলামি কৰি পাতি সেই কপিকে যে কৰে সেইবোৰ কৰি পেলাই কৰিছে একদম নাচাই দেই নিজে ইমান চিন্তা আছিলে নহয় মোৰ লগতো তেনেকুৱা কেতিয়াও নকৰা নাছিল বহুত সেইটোৰ কাৰণে বেয়া মই কি কৰিম আৰু কচোন এতিয়া তাই জেলত থাকিব লাগিব ভাবছি ইচ্ছা আছে My lord, in written statement, my lord, para 8, my lord, it is shown that opposite party's grandfather's name is appeared in the voter list 1985. 25, 85. Okay. Hmm?
This is the book, to take one.
Okay. Facebook lawyer কিবা তাকে কৰে ইমান ভালকে চাইছিলে চাচোন তাকে তাকে একটু লিখা নাই কিন্তু সিরিয়াল নাম্বার বোর্ড দিছে আরে একটু দিয়াছেন একটা নাম্বার আছে আমার
Please come to page number 31.
31 Yes, my lord.
Read para 9 very slowly.
That my grandfather's name has been recorded in NRC details at village Moisha, and also my grandfather's name has been recorded in the certificate of the registration 1950, which is issued by the Deputy Commissioner Gwalpara. A photocopy of the detail and certificate registration are annexed with markers annexer.
Very good. So according to you, your grandfather's name has been recorded in the certificate of registration of 1950.
50.
Good.
Thank you, Shashan.
Please come to page number
50, Shashan.
27.
27.
In the written statement. The first one that just now read was a part of your
27.
affidavit in evidence. Now read para 14.
That the opposite party and her father, along with her grandfather, never migrated from anywhere or any foreign country by the country. They are the by birth Indian citizen.
Now, please read. Though it was not accepted, or it was rejected. Read page number 36. Affidavit of your projected father.
36.
There are 10.
that my daughter and I, along with my father and so my grandfather, born and brought up West Moisapara Part 2, but presently I am along with my wife have been residing Khaldoba Part 1, hence my voter ID also recorded as Khaldoba serial number. Later on, my lord, see, they were staying
So
at
according to
Khaldoba.
the projected father,
Yes, my
let
lord.
us assume this is there for the purpose of sending the matter back to the tribunal. Let us say the projected father say, my daughter and I along with my father and also my grandfather. Right? So the projected father is saying that his daughter, he himself, his father, and his grandfather or grandfather. his
Born and brought
grandfather,
up Moisapara Part 2.
born and brought up at West Moisasor Part 2.
Oh, Moisasur. Yes,
Right.
so bilik.
Now, then what was the need for registration of grandfather in the year 1950?
60.
Page
Page
31, para 9. What was the need for registration? What was the need for registration? Even born, Gajendranath Sarkar himself, Gajendranath Sarkar's father, Gajendranath Sarkar's grandfather, if they are born in India, what is the need for registration? So nothing is trustworthy. Not a single document is reliable. Trying all parts here, there, whoever you get that, right?
Yes, my lord.
So towards any instance that it should be returned back to the tribunal for any consideration.
My submission is that only, my lord.
No, no, what issue, you have to have some.
Yes,
base, right?
yes.
What is that base?
Full niki, photo ka, But in this case, the tribunal, my lord, mentioned one case, my lord. I have not gone through it, my lord. So let the matter be listed at 2 p.m. so that I can go through it, my lord.
Enough.
Yes,
See, any document is.
Yes, my lord, yes.
reliable,
Because,
would have definitely considered.
yes, my lord.
Is it reliable? You can show us.
It
that
was
it's
not, okay?
reliable, you would have considered.
Yes, my lord, yes.
You know the outcome.
Because she is married now, having children, my lord. Apparently, she is Indian, my lord. But because of conducting, my lord. Tata করলে না, কিছু,
Counsel for the petitioner. Please take your seat.
Any matter, acha. কিবা করে এরা জাজমেন্ট গুলো বলিব মাথা করে চাই নাকি সামনে ইমান ভুল বাপরে
MS J. Sharma, learned CGs,
আমি দিব কোন গালি দিমু কেন কি কিসনে
for the response number 1.
এটা কোনটা
Also heard this standing counsel book department.
Nego kis no to get patay দিয়ে করতে
And 4.
দিবি না না এটা মান করি কন্ডাক্ট করে
Are you also appearing for the respondent number 3 with the secretary political
Yes, ma'am.
body department? Or
Secretary,
the
Government
law
of
and
Assam,
advocate will appear?
Political B department.
Will appear?
Yes, ma'am. 3 and 4, my lord, I will appear.
2, 3 and 4.
2, 3 and 4.
And Mr. P. Sharma, additional senior government advocate Assam,
This is not a matter, but this.
for the respondent number 5.
Code number कितना? My lord, I have another matter in code number.
Please go.
May I go, my lord?
While making necessary verification pertaining to number 25 Bullockganj Legislative Assembly constituency in the year 2005. The petitioner failed to place relevant document before the said LVO. Before the concerned LVO. And as such, on 12/05/2005, the LVO submitted the report before the electoral registration officer of said number 25 Bullockganj LAC. Specifying that within bracket colon लिखिबा, no document found with regard to the petition in the format submitted the report in the format annexure A. On the basis of the said report of the concerned LVR, the concerned electoral registration officer or number 25 Bullockganj LSC on 18/08/2005 specified that during house to house enumeration of said constituents LSC name of the petitioner was declared to be an Indian citizen as an ordinary resident of Moisha Part 1 as enumerated in the draft electoral roll. And from the report of the LVO, put in bracket annexure A, submitted as per annexure A. The concerned ERO expressed his doubt, each doubt, ITS, about the citizenship of the petitioner. And accordingly requested the Superintendent of Police Board to brief for verification of the matter. Under the Foreigners Act 1946. Submitting the said request in the format as per Annexure B. On the basis of the said report of the LVO in the format Annexure A, as well as the request of the ERO in the format Annexure B, the Superintendent of Police Board Dhubri filed D voter case number 268/D/07, comma, on 23/05/2011, forwarded the matter to the Foreigners Tribunal, Dhubri, expressing doubt about the citizenship of the petitioner and seeking its opinion. And sought for its opinion. And the equivalent, so that is opinion, seeking its opinion as to whether the petitioner is a foreigner under the Foreigners Act 1946 or not. The opinion, yes, sir. Opinion about the nationality status of the petitioner as to whether she is a foreigner. The Foreigners Act 1946. On receipt of said reference, initially case number F.P.C. number F.P.C. oblique number 9926 oblique GKJ oblique 11 was registered against the petitioner under the IMDT Act during its course. However, after the judgment of the Honorable Apex Court in the case of Sarvananda Sonowal versus Sachin Skinner, this arrogance in the The said FTC case number 9926/GKJ/11 was re-registered as FT-10/AGM/272/2016 under the foreigner section. And the matter was transferred to the Foreigners Tribunal 10th February. In which the said tribunal on 09/08/2016 issued notice to the petitioner on receipt of said notice. The petitioner filed her written statement in said such and such political case on (19/9) 2016. Thereafter filed her affidavit in evidence on (22/11/2016). By filing an application on 8/12/2016 the petitioner submitted two more exhibits before the tribunal. Thereby altogether, the petitioner submitted 8 exhibits before the tribunal to prove her citizenship. The petitioner was cross-examined on 08/12/2016. The petitioner submitted the following exhibits to prove her case of citizenship: 1, 2, 3, 4, 5, 6, 7, 8. After considering the relevant materials and the exhibits placed by the petitioner and the evidence adduced by her, the learned foreigners tribunal held February, Assam in said case number such and such. By the impugn opinion / final order dated 05/04/2017. Opined that The petitioner is a foreigner of post 1971 stream who had entered into Assam on or after 25/03/1971. And that the evidence as well as the documents filed by her in support of her case / version are found to be contradictory, are not sufficient and trustworthy to prove her citizens, to prove herself to be an Indian citizen by birth to genuine Indian parent. Being aggrieved to decide final order / opinion that is 05/04/2017 passed in said such and such by the 11th member Foreigners Tribunal 10th to read. The petitioner filed this petition on 17/05/2017. The court, while issuing notice to the respondents on 19/05/2017, called for the records of said application number such and such from the Foreigners Tribunal 10 to Assam. And in the interim, directed that the petitioner shall not be taken into custody and deported from India. Directed that in the meanwhile, the petitioner shall not be taken, deported from India. With the observation that with the further direction that directing her to appear before the Superintendent Police Board to be within a period of 15 days from the date of the same order, i.e. 19/05/2017, and to furnish a bill bond of rupees 5,000 with one local surety of the like amount to the satisfaction of the said authority. And thereafter petitioner was allowed to remain on bail. Next. We have perused the records of the learned Foreigners Tribunal, wherein the impugned final order / opinion was passed. In her written statement filed on right. The petitioner stated that we didn't make it smaller. Name of her deceased father as Gajendranath Sarkar. She was born and brought up at village Maisa, MAISA, Part 1, UNPS Agomani in district of Dhubri. 3. He was married to one Sukumar Roy, SHUKUMM, son of late Raman Roy, of village Kalduba, Part 1, UNPS Agomani district Dhubri. 4. Name of her grandfather is Radha Raman Sarkar Biswas, as recorded in the NRC details at village Maisa, district Walpara. Next. Name of her grandfather appeared in the voter list of 1966 under number 35 Golobganj LAC at village West Maisa, Part 2, Agomoni. As well as in the voter list of 1970 from the same place. Next. That name of her grandfather also appeared in the voter list of 1985 under 25, under number 25 Golobganj LAC at village West Maisa, Chor, Part 2. West Maisa, Chor, Part 2. PNPS, PO Agomoni, Police Station, Golobganj District. Next, she was born and brought up at village Maisa and obtained a birth certificate in her name from Halapura Public Health Center. And that what the number is. She was born on 10/02/1994 as per her birth certificate. As she was below 18 years prior to her marriage, she did not cast vote. But after her marriage, when she went to enroll her name, the authority concerned recorded her name as within the colon letter D. Name of her father is Gajen Sarkar, alias Gajendranath Sarkar, son of Radharaman, alias Radharaman Sarkar Biswas, alias Radharaman Sarkar, and is having a family identity card by serial number 609787. That is recorded in the name of her father, Gajen Sarkar. Which can be considered as a linkage certificate along with her birth certificate. Next. Name of her grandfather recorded in NRC details as Radharaman Sarkar Biswas. But in the voter list from 1966 to 1985 was recorded as Radharaman Sarkar. That her father, Gajen Sarkar and Gajendranath Sarkar is the one and identical person. Similarly, her grandfather, Radharaman Sarkar and Radharaman Sarkar Biswas is also one and identical person. Her father, along with her grandfather, never migrated from anywhere or any foreign country. And that they are Indian citizen by birth. After her marriage, she was known as Monomoti Sarkar. Sorry, after her marriage with Sukumar Roy, she was known as Monomoti Roy, as she had taken the surname of her husband. And accordingly, her name was recorded as Monomoti Sarkar. I recorded Monomoti Sarkar Roy from Monomoti Sarkar. That Monomoti Sarkar and Monomoti Roy is the same and one person. In her affidavit in evidence, next, petitioner submitted that she is a resident of village Moisa, Part 1, Pio in Sagobani, district of Pick. She was born and brought up at Kalduba, at village Kalduba, Part 1, Pio and Sagobani, district of Pick. Name of her father is Gajendranath Sarkar and mother is Ambarsa Sarkar, AMABARSHA Sarkar. At the time of puberty, she was married to one Sukumar Roy, son of late Ramesh Roy, president of village Moisa, Part 1, PNP Sagobani district. And exhibited a copy of marriage linkage certificate issued by the Secretary of Agobani Gaon Panchayat as Exhibit 1. She was born on 10/02/1994 at Kalduba, Part 1. And in that figure, submitted the birth certificate issued in her name by the Halakura PHC, marked as Exhibit 2. She deposed that name of her father in some documents are recorded as Gajen Sarkar, and in some others as Gajendranath Sarkar, whereas Gajen Sarkar and Gajendranath Sarkar indicate same and one person, an identical person. She deposed that name of her grandfather was recorded as Radharaman Sarkar Business, Radharaman Sarkar. And all those names are one and identical. Name of her grandfather, Radharaman Sarkar, grandmother, Rangamala Sarkar, and her father, Gajendranath Sarkar, was enlisted in the voter list of 1966. The number 35 Golokan LSC. At serial number 22, 2021-22, house number 10 of village 102, Paschim Moisa, Part 2. Placed as exhibit 2. Name of her grandfather recorded in NRC details at village Moisa. And further, his name was also recorded in the certificate of registration, CROR Capital Road, 1950, issued by the Deputy Commissioner Kualpara. And the NRC details and the certificate of registration marked as Exhibit 4. She further reduced the name of her father has been recorded in the caste certificate issued by the Office of the Chairman, District Scheduled Caste Development Board, and exhibited as Exhibit 5. Certificate of registration, where the NRC details are marked as Exhibit 4. She also placed the voter list of 1970, reflecting names of his grandfather, pertaining to 35 Golokan LSC. In addition to that, petitioner also adduced certain evidence in her evidence chiefly that name of her grandfather was unlisted in a 1985 voter list of pertaining to 35 number 35 Golokganj LSC. 25, not 30, 25. Agorbilak 35. And also record in the family identity card. However, she did not exhibit those documents and produce only photocopies of the same. During the proceeding pending before the learned tribunal, the petitioner on 8/12/2016 submitted an affidavit producing a certified copy of voter list of 1970 and 1985 pertaining to number 35 Golokganj LSC and number 25 Golokganj LSC to show that name of her grandfather was reflected in the same voter list of 1970. Voter 1970 voter list of 1970. Name of her grandfather and father recorded in the voter list of 1970 pertaining to number 35 Golokganj LSC, as well as 1985 voter list of number 25 Golokganj LSC along with her grandfather and her parents. Grandfather, grandmother, and her parents. Record also reveals that the petitioner on 8/12/2016 submitted an application to allow DW2 to adduce evidence on her behalf. However, the learned tribunal on 8/12/2016 rejected her said application clarifying that the petitioner did not disclose the identity of DW2 in her said application. Filed an application with an within bracket paper, application number 1130 dated 8/12/2016. Thereafter, on 21/12/2016, the petitioner filed another application, file number 1174 dated 21/12/2016 before the said tribunal, submitting the affidavit of DW2 on behalf of the said proceedee / petitioner. At the tribunal, by order dated 21/12/2016, rejected the prayer of the petitioner to produce any evidence on behalf of to produce an evidence on behalf of DW2 on her behalf. As earlier on 08/12/2016, her prayer for such prayer, similar prayer was rejected as she failed to disclose the identity of the DW2. For the same reason, for the same reason, the application of the petitioner number 1174 public dated 21/12/2016 filed by the petitioner to adduce evidence on behalf of DW2 was also rejected. After hearing the parties, the learned tribunal for the following reasons opined that petitioner failed to establish her case that she is a genuine Indian, that she is a citizen of India by birth through genuine Indian parents, and accordingly opined that she is a foreigner of post 1971 stream while entered into Assam on or after 25/02/1970. The reasons are as follows. Perusal of the exhibits, particularly exhibit 1, there's the certificate issued by the Secretary Agomoni Gaon Panchayat on 10/7/2015. In favor of the petition. That was also countersigned by the block development officer, Agomoni Development Block, wherein it was specifically stated that the petitioner Monomoti Sarkar, daughter of Gajendranath Sarkar, and Anjana Bala Sarkar of Kalduba Part 1 village under Agomoni Gaon Panchayat, under Agomoni Revenue Circle of District Dhuburi, aged about 18 years, was a resident within the jurisdiction of the said Gaon Panchayat area. Said Monomoti Sarkar got married on 02/07/2013 to Sri Sukumar Roy, son of late Roman Roy and late S.A.J.J. X.A. Roy, who are resident of Kalduba Part 1 village, Agomoni Revenue Circle of Dhuburi district. And that said Monomoti Sarkar has now migrated from Agomoni Gaon Panchayat area to the said locality Kalduba Part 1 by virtue of her marriage. It was solemnized as noted above. The petitioner did not adduce evidence of any such authority who issued the said certificate of Agomoni Gaon Panchayat dated 10/7/2015. As such, the said certificate, Exhibit 1, was failed to be proved by the petitioner. It is also noted that in the said certificate issued by the Secretary Agomoni Gaon Panchayat, the petitioner, along with her father, projected father and mother, was said to be the resident of village Kalduba Part 1 under Agomoni Gaon Panchayat. Exhibit 2 is the birth certificate of the petitioner issued by, it's the second issue birth certificate issued by the Register of Birth and Death, Halakura Public Health Center, issued on 8th of October, 2015, saying that the petitioner Monomoti Sarkar, within bracket female, date of birth 10/02/1994, place of birth Maisa, Part 1, mother Anjana Bala Sarkar, father Gajendranath Sarkar. Former address of their parent is village Maisa Part 2. The resident, the time of birth is Maisa Part 2. Under Post Office Agomoni, District Dhuri. And the date of issue of this birth certificate was on 17/02/1994, file number 634. However, petitioner did not prove the said birth certificate issued by the register of birth and date Halakura PHC on 08/06/2015 by reducing the evidence of the issuing authority. It is to be noted herein that in the said birth certificate, the address of the petitioner at the time of her birth was soon to be in Maisa Part 2. Exhibit 3 is the, as noted above, is the voter list of number 35, Gulabganj LSC. Issued in the name of one Radharaman Sarkar, son of Premananda, Rongo Mala Sarkar, wife of Radharaman, and Jogendranath Sarkar, son of Hori Datta, village 102, West Maisa Part 2, West Maisa South Part 2, under Agomoni Police Station. Exhibit 4 is the certificate of registration issued by the Deputy Commissioner Golpar on 25/01/1950 in the name of one Radha Raman Sarkar, son of late পরমানন্দ সরকার, applicable only for the Kasar district only. Oh, the petitioner did not prove the said certificate by additioning any evidence of the issuing authority of certificate of registration issued on 25/1/1950 by the Collector/Deputy Commissioner of Health. Exhibit 5 is the caste certificate dated 10/09/1984 issued by the Chairman, District Civil Caste Development Board. Certifying that one Gajendranath Sarkar, son of Radharaman Sarkar of village Maisa Part 2, Post Office Agabani, District Dhuri, belongs to Namasudra subcaste, recognized as a scheduled caste under the Constitution Order 1950. Clarifying that the Gajendranath Sarkar, the resident of Maisa Part 2 of Post Office Agabani, under Golokganj Police Station of District Dhuri. Exhibit 6 is the electoral photo identity card of one Gajendranath Sarkar, son of Radharaman, resident of village Kaladuba, AM Khanda, the police station Golokganj, District Dhuri. Exhibit 7 is the voter list of number 35 Golokganj LSC pertaining to 1970. Of 102 West Moisasor, second part 2. Showing the name of one Radharaman Sarkar, son of Premananda, Rangamala Sarkar, wife of Radharaman, and Jogendranath Sarkar,
Maybe
son of
happens next time.
Hori Das.
I will issue 5th December.
Hori Datta,
Dismiss shipping could be government.
or written as Hori Datta.
She may be good to go for, Really. Yeah.
Exhibit 8
Dismiss could work.
is a photo list of number 25 Golokganj LSC, year 1985, of village number 58 West Moisasor Part 2, where name of one Radharaman Sarkar, son of Paramanand, Rangavala Sarkar, wife of Radharaman, Sakti Saran Sarkar, son of Radharaman, Anima Sarkar, wife of Sakti, Gajendranath Sarkar, son of Radharaman, and Anjana, Sarkar, wife of Gajendra. Reflected. However, endorsed to exhibits eight, exhibit 7 and 8. No date has been issued as to when the certified copy was provided to the petitioner. Mr. Fine. Whether the voter list of 1970, exhibit 7, there is a photo, I think so, there is a photocopy here, the petition. Page number 16 needs to be proved under the Evidence Act, being a certified copy.
Well, it need not be proved if it is a certified copy. But
Now, read section 26 of this Evidence Act, whether it is a certified copy.
Evidence six.
Do you have the Evidence Act with you?
I don't have, but
Not section 76. No.
26.
Section 76 provides, my lord, certified copies of public documents. Every public official having the custody of public document, any person has a right to inspect, shall give the person on demand a copy of it on payment of the legal fees therefor. Together with a certificate written at the foot of such copy that it is a true copy of such document or print thereof, as the case may be. So, in the instant case, my lord, in page 16, in fact, the certificate that it is certified to be true copy is not there.
It's there.
Prototype prototype is there. Prototype is a
What do you mean by prototype?
Prototype means, my lord, it's a true copy.
Exactly. Come to page number 14.
Prototype is a true copy.
Come to page number 14.
14, madam.
You will see the date on the left,
True copy
and it is Pramanito
Yes.
Protilipi. Same thing you will find.
Pramanito Prototype. ma'am. Pramanito, certain true copy.
Page number 18.
18, madam. Prototype Prototype.
No date, it's Pramanito Protilipi.
Yes. In fact, my lord, there it is we go to the section 76. It's further said, my lord, certificate would put and send true copy of such documents or part thereof as the case may be, and such certificate shall be dated and subscribed by such officer who is with his name and his official title. Here, name and official title should be there, my lord, along with date. Date, name, yes, my lord, date, name, the name of the person, my lord, who has
Issuing
issued.
authority is not there.
Yes, not there. Date is not there.
That is why it is Swastaito.
Yes.
It is not that Hoito Pramanito Nokol.
And for this, in fact, my lord, this honorable court in the judgment has said, as there are one, apart from other part of the India, this country, this is in public domain, that this kind of certificates are, my lord, documents are available in the state of Assam. So it needs to be proved in the tribunal. There is a judgment of this honorable court, my lord,
It's to be
proved
proved in the
in,
tribunal.
in tribunal, my lord, by calling the writer of the, my lord, documents.
No, in some of the cases, we found that the proceeding adduced the evidence or it was
Yes, yes. my
all
lord.
for the.
No, that's why, my lord, this
tribunal
honorable
call
court, because the authenticity of the genuineness and genuineness of the documents has to be proved by the, my lord, issuing authority. There is a judgment, but in some cases, my lord, certified copies we are accepting. It's, my lord,
Issued as per section 76. no
yes, my lord, as, my lord, generally certified copy of a, my lord, public document is accepted as a evidence, piece of evidence. There is no problem on that. But in particular, in this kind of cases, for the purpose, my lord, there, as there is a, my lord, in the public domain, there is an issue that, my lord, there are some fake certificates, fake documents are there. So specifically in these cases, the court, this honorable court has decided, my lord, that the event is brutality need to be proved in the tribunal, my lord. I can provide the judgment, my lord.
মানে কি জানেন?
Kaman kulbo kene kote den. No? Kukuyo tigumbo, kukula tigumbo. Actually, হয়ে apparently মানে Indian বিয়ে করেছে একবার নেবো নিকে একটু ড্রেসিং মানে গিরিন কারণ ভিডিও बहुत बुलाने मतलब बस ये बच्चे के ना हाँ समी में तो खाली तो पड़े मुड़ी वाले एकदम है इन्हों बहाना जो प्रीति Naman sila ini friend din to India mo. Ini kan dia tu angkor dia punya lagi. Apa bukan? Ini tu ini dia jangan dia.
itu percaya
Apa India? Saya kabur India. Pikir dia kan cuma muncul ke Nah, karena pakai itu dah berbeda. Maka dia buka sini dah. Buka di sini. Ini di mana? Baik besar dan selagi berapa ini loh.
From the above, we have seen the petitioner failed to prove her Indian citizenship as required under section 9 of the Foreigners Act 1946. Which provides that for the reasons above, we found that the imperial final order public opinion dated 05/04/2017 passed by the London Member of Foreigners Tribunal in case number FP within bracket 10 bracket close oblique ACM oblique 272 oblique 2016. The reference FP case number 9926 oblique ZKJ oblique capital Roman 2. And reference within the colon E Uttar case number 268 oblique D oblique 07. Holding the petitioner to be a foreigner of post 1971 stream were entered into Assam honor after 25/03/1971 doesn't conform any interference. Accordingly, it's the petition being devoid of any merit. Stands dismissed. The interim order passed on 19/05/2017 in favor of the petitioner accordingly. Hence, we call smart safety order. Registry cell. Then back the records of application number FP such. The furnace driver number 10. Allow what a copy of this order. Registry shall also communicate this order to the Superintendent of Police in order to bring forward it. Order stage.
Yes. Well, in this case, my lord, I will advise my client to go for Supreme Court, my lord. So interim order may be continued till for the period of 1 month, my lord, so that she can go, my lord. Otherwise, you will go to jail, my lord, after order. That is my humble submission before your lordship.
At this stage, Ms. KDB, learned counsel appearing a petition. Some is that she will advise the petitioner to approach the Honorable Apex Court to prefer an appeal and pray to keep in abeyance the order passed above for a period of 30 days. Prayer allowed. The order passed, we passed as a book. It will be kept in abeyance for a period of 30 days.
Highly obliged. Last one.
May I please also. My lord, page 62 is the imbuing order also. May I read the order also?
Just. Please take your seat. I don't really read my thing. Thank you. Yes, which is your linkage? Okay, we'll come back at 2.
Okay.
Your link document. Just a minute, just a minute. Link document, page 25. Page 27 is the certified copy of the voter list of 2016. Your name is Amir Ali Khan. And you are saying that Matab Ali Khan is your father, son of Pashan Ali Khan. And you are son of Matab Ali Khan and Jamirun Nisa. That's your case, right? That's of voter list of 2016 of village 124 Balarsar. Now, page 26. Same, Matab Ali Khan, Pashan Ali Khan, Jamirun Nisa, Matab Ali Khan, and Amir Ali Khan. You're the son of Matab Ali Khan. Voter list of 2010. Now, page number 25. Whether page number 25, this voter list of 1997 from 124 Balarsar that you have placed before the tribunal can be considered in evidence? No, that cannot be. Prior to this, while Mr. Payeng was reading section 76 of the Evidence Act, you heard what has to be there. There cannot be a translated copy. The translated copy is not the certified copy. Right? Maybe that's how you have to, that if they have rejected, they should have tell you, they should have informed you. These 3 voter list, because only in these 3 voter list, name of your projected father and projected grandfather is specifically mentioned, Matab Ali Khan and Pashan Ali Khan, whereas in the other 2 cases, the previous voter list that you have placed before the tribunal that are different, that belong to Matroghola village. This is 1985 voter list. Right. Why there is no voter list of Zamirin Nisa at Matragola? Because she was 29. That's the reason we're asking prior to 1985. These are all post 71 documents. Not Matab Ali Khan. One is Matab, one is Matab Kha, and that's belong to Matragola. That's the reason we're asking you. You have the valid document showing your full name of your father, full name of your grandfather, only from the voter list of 1997. And 1977 is not the certified copy of the voter list. There are, these names, had there been full family, as per the judgment of the Supreme Court that you have seen, names there may be discrepancies. But what in that particular judgment was very specific. His lordships therein have clarified only the names, the name of the concerned father of the proceeding. There are some mistakes in it, but the house number, serial number, and the name of the other persons in that voter list remain intact. That's how, in that circumstances, Honorable Apex Court have said, yes, though in this, the father name is ABCD, not ACDB, so it should be considered as same because the other names, whatever available, were correct. So here only Pathan Kha, Matab, so it's incomplete. Because 1970 voter list, 1966 voter list, if you have shifted in the 1990, why the voter list only in the 1997? Why not prior to that? You have said in your written statement that you have shifted to Balarsar, India, 1990. Then why only in the voter list of 1997 the name of your parents figured? Why not immediately thereafter? It took 7 years in a Balarchar. Which year? Which year? That's the reason you have adduced evidence. Which year? You have said in your written statement that you have shifted in the year 1990. Right? If you have shifted in the year 1990, from 1985, At least in the year 1990, your name should have been there in the voter list of 1990. And thereafter, why only in the year 1997, the name of your parents figured in the voter list? It should have been immediately thereafter. What happened in between? That's not, it have to be do it before the tribunal, not here. What chance? It's your case. We are nobody to here give you chance. You have to prove it. We do not know. It is up to you whether you produce it or not. We have nothing to do. We have to here and only we have to establish. That's why I'm asking you. Hmm. Hmm. Mr. Payang, is it possible? The voter list of Balarsar of the year 19, because that's a true copy like thing. We do not, it's not a certified copy. So 97, we are not holding it. No, 90, page 26, 27 are certified copy. That's translated copy. That cannot be accepted. There is already a judgment passed by Justice Goswami along with me. Tell us. Petitioner has stated they have shifted in the year 1990.
There are two sets of documents, my lord. One with regard to Motorgula and what is with regard to Balarsar. And what interesting is that, my lord, what is there in Motorgula is consistent with each other, and what is there in Balarsar, it's consistent with each other. But the documents of Motorgula and Balarsar is contradicted. So two sets of documents. Your lordship may kindly see the 1966 and 1985. Suppose 1966, 70 and 80, my lord. In 1966, it is village Motorgula. The person's names are Pathan Kha. It's clear, my lord. Pathan Kha. The father name is Abdullah Kha, Adalat Kha, aged about 70 years. And the projected father, whom the petitioner is projecting, my lord, this is Matab. Not even Kha is there. And the father name is Pathan. Pathan is clear, mother. Pathan. Similarly, in 1970, it is Pathan Kha. I accept that Pathan may be Pathan Kha. And the Matab Kha, their Pathan Kha's father name is Adalat Kha. And Matalab Kha's father name is Pathan Kha. Age is 75 and 29. This is consistent with the mother 66 voter list. And this is consistent with the Matab Kha, page 24. This is Matar Ghola Malad. Matab Kha, here father is Pathan, and age is 39. So there is no discrepancy. Up to Malad, here wife name is Jarimon Nessa Malad. Jarimon Nessa, wife of Matab, is about 29 years. So there is no contradiction with all these documents. 66, 70, 85. Now, Madam, ignoring the 97 voter list, Madam, if you ignore, same things are there in 2010 voter list. 2010, from 2010, 2016, these are the voter list of Madam New Village, Balarsar, where the petitioner exists. Here the petitioner is now, Madam, petitioner exists. Petitioner is known, written as Madam, page 26. It is Amir Ali Khan. Here the father name is Matab Ali Khan, not Matab Khan, my lord. It's Matab Ali Khan. And what there in the top, my lord, 355 serial number, the Matab Ali Khan is a voter. His father name is Pasan Ali Khan, not Pathan. Pathan is totally different. Pasan is totally different. Pathan Ali Khan is it about 67 years. And here there are some similarities, but it is not Malad. And here mother name is Jamiron Nessa, not Jariman, as stated Malad there in 1985. Your mother is Jamiron Nessa, Matab Ali Khan. So he Malad stated that the family of the petitioner shifted in 1990 to the Balasar. Malad, the fact here is Malad, after 2009, in fact 2006, this is 1997, the petitioner is in Balasar. The case is registered in Balasar against this Matab Ali Khan, Amir Ali Khan. He is trying to project that Matab Khan of 1985 and Pathan Khan of 1970 and 66 as father and grandfather of the petitioner. But for these inconsistencies, my lord, in between the voter list of 1966, 70 and 1997, we cannot accept that this Matab Ali Khan, son of late Pasan Ali Khan, is the mother, the son of that son of Pathan Khan of 1966. This cannot be accepted. And we cannot say, my lord, this Pasan, this Matab Ali Khan of 2010 and the Matab of 1966, who is the son of Pathan, not Pasan Ali Khan, is the same person. And to that effect, there is no evidence. They have not brought any evidence, my lord, to prove that Pathan, that my lord, Matab Ali Khan, son of late Pasan Ali Khan, and Matab Khan, son of Pathan, is the same person. Statement will not do, my lord. The statement will not do. They have stated. Secondly, they have stated shifting. My learned friend is saying, my lord, they have stated regarding the shifting. Shifting, there is a statement, but there is no proof that they have shifted. To that effect, they have not brought any evidence that they have shifted. The only question here, my lord, that is the only question, whether the same person, Matab Ali Khan and Matab Khan, is the same person. If that is proof that Matab Ali Khan, son of late Pasan Ali Khan, is the same, whose name is there as Matab, son of Pathan in 1966, my lord, there can be some conclusion that yes, he may be the citizen of India on the basis of the voter list of 1966. And at least until, my lord, that is proof that Matab Ali Khan, son late Pasan Ali Khan of 2010, and that Matab of 1966, son of Pathan, is the same person. We cannot accept the conclusion that the petitioner is a citizen on the basis of, my lord, the voter list of 2010. To that effect, my lord, I would like to. And secondly, he relied on some voter list of documents of 1966 prior to 1966 of that revenue receipt. Some revenue receipt he have relied on, my lord. The revenue receipts cannot be accepted as a documents for the purpose of citizenship, my. There are judgment and revenue receipts, anybody can pay the revenue receipt for any purpose. What he has stated in the WS and evidence, WS, that has to be proved by bringing evidence, cogent and reliable evidence. That is the law, my lord, established. That I would like to refer, my lord, WPC 264 of 2017, 2641 of 2017 to that effect, my lord. Here, my lord, the question was. No, my lord, before that, my lord, I like.
Mr. Hussain, take your seat.
Sorry, my lord, I'd like to refer the another case. In fact, that was not the case for reference in this case, my lord. This is, my lord, 3071 of 2016, my lord. Zainaluddin versus Union of India. In this case, my lord, para 34, no para number is there. But here the question was, my lord, what is to be proved, my lord? The court has several decisions that when the citizenship status of proceedee is questioned, that too by state, it is the burden duty of the proceedee to disclose all material facts in his position at the first instance itself. He has disclosed some facts, my lord. In this case, in the written statement, failure to disclose material facts in the written statement by itself may lead to a drawal of adverse presumption against the proceeding. However, mere pleading of material facts in the written statement is not enough. That part I want to use. However, mere pleading of material facts in the written statement is not enough. If material facts are disclosed, those would then have to be proved by adducing cogent, reliable, and admissible evidence. So here, my lord, two facts he needs to be proved, my lord, that Matav Ali Khan of 2010 and Mataf Khan, son of Pathan of 1966, is same and one person. That facts, even though he has stated, that is not proof. No evidence to that effect has been brought. Second issue is, my lord, shifting from one village to another, because, my lord, discrepancy arises while after shifting. My lord, the projected shifting. According to him, he shifted in 1990. And the discrepancy arises only after 1990. So had it been, my lord, some names are, my lord, the discrepancies were arised in 1985 and 70 itself, then we could accept it. But discrepancy arises only after shifting, the projected shifting. So shifting is to be proved. If it is, they are the same person, my lord, that shifting is also not proved. Even though it is stated, my lord, that is not proved. And to that effect, there is no evidence. So in absence of these two facts, my lord, in absence of evidence of these two facts, my lord, the shifting is not proved. And it is not proved that Matav Ali Khan, son of Pasan Ali Khan of 2010 onwards, and my lord, Mataf Khan, son of Pathan of 1966 and 70 is the same person. It's just trying to project that they are the same person and they are my ancestors. And on the basis of that, I may be granted citizenship. Discrepancies, my lord, with regard to the discrepancies, we can say, as your lordship has rightly pointed out, in the Sirajul Haq case, my lord. Sirajul Haq, there was, my lord, in all other case, all others' name, there is no inconsistencies. Only in, my lord, contradiction was that Kafatullah, F become M. Kafatullah become Khematullah. That was the only difference. So we are not saying, my lord, but we are not saying that, my lord, the M may become F sometime. We have no problem on that. But the name of, but in that case, my lord, father's name was same, grandfather's name was same, other family members' names were there. And their names were, my lord, there were no discrepancies in their names. But here, my lord, the father name is different. Father name has been changed. Grandfather name is changed. Mother name is changed. So only there is only similarities, my lord, the Matap. Ali has been included. Kha has become Khan. The father name has become, my lord, Pasan instead of Pathan. So this is not a, my lord, minor discrepancies. So in case of minor discrepancies, if, my lord, Matab Kha has become Matab Khan, we could accept it also. But Matab Ali Khan, the father name also different, my lord. Father name is not Pathan, it is Pasan Ali Khan now. Earlier it was Pathan. So how can we accept it? It's a minor discrepancy. This is not a minor discrepancy, my lord. So my lord, my lord, so my humble submission is that, my lord, the tribunal has committed no error. Tribunal cannot presume without, my lord, evidence, without producing evidence. If the petitioner had evidence, they should have produced all the evidences before the tribunal. Without the evidence, tribunal cannot go beyond the evidence, my lord. Tribunal has to appreciate the evidence, whatever available in records. And on the basis of records, he has to give his opinion. So tribunal has committed no wrong, my lord, by declaring the petitioner to be foreigner on the basis of, my lord, records available in the record. That's my humble submission.
My lord, I will reply. You want my knowledge, my friend has submitted also.
Please.
Lordship, first of all, my learned friend has referred to documents, regarding the revenue payment receipt. The revenue payment receipt was exhibited before the learned tribunal only to establish establish the existence of this person at that relevant point of time. It is correct that the revenue can be paid by anybody, but the document exhibit 2, that is here annexed 2, patta. Patta cannot be given in others' name, lordship. And this patta is in the name of the father of the petitioner, lordship. And secondly, lordship, the petitioner has submitted a very comprehensive WS, very comprehensive evidence before the tribunal, lordship. It is not that the petitioner has not expressed anything which is his knowledge, in his knowledge. He has explained everything, lordship. Lordship may kindly go through the written statement, lordship, at page 42. Page 42. Very comprehensive, lordship. I have gone through the written statement and the evidence, lordship. Evidence which he adduced was not reverted, lordship, by the state, lordship. The DW1 was not cross-examined by the before the learned tribunal, lordship. These are all lacuna, procedural lacuna, lordship. And my lord, the tribunal never looked into all those aspects regarding the authenticity of the certificate copy of voter list of 1997. Lordship may kindly see page 63, the relevant portion of the order, wherein it is stated regarding the patta only, last fourth para from last, lordship, from bottom. In his page 63, may I read the relevant portion, lordship, only 2 lines, lordship. In his evidence on affidavit, OP stated that his projected father had obtained a patta, exhibit 2, but OP has not been able to submit any document regarding the present status in respect of the aforesaid plot of land described in exhibit 2. Here is asking for the present status, but the existence of that relevant point is not denied, lordship. And as has been discussed here before this honorable court, in the previous para, the learned tribunal has discussed about the discrepancies is named, but no detailed discussion is made regarding those exhibits, lordship. These documents are not challenged, lordship, before the learned tribunal, which was produced. The evidence of DW was not DW1 was not cross-examined, lordship. Lordship may lordship is aware regarding the full bench decision, lordship. in paragraph 93 of the full bench decision, Muslim Mondal, regarding fair trial, Lordship. That was not done before the learned tribunal, Lordship. Had there been any cross-examination, had there been rebuttal of documents I produced, that would have been a fair trial. That was not done. Lordship, paragraph 97 also states regarding fair investigation, Lordship. That was also not done. In Muslim Mondal judgment, Lordship, paragraph 20, 120 and 22 states about cross-examination. If there is no cross-examination, the authenticity of the documents are said to be accepted, Lordship. Those observations are there in the full bench decision. Lordship may kindly see the notice that I have. I also have averred before the learned tribunal in my written statement, Lordship, regarding notice. It was not in proper format as prescribed by the Honorable full bench, Lordship. Para 124, 89, 103, all these paragraphs described regarding notice, how to serve a notice. The main grounds were absent in the notice, Lordship, but these are mandatory to be there in the notice before serving that to the proceeding, Lordship. So, Lordship, there are procedural lapses also, Lordship, and my humble prayer is that if Lordship is regarding the 97 voter list, that this is not a certified copy, this cannot be produced, then Lordship, it is the mistake of the state. I have a judgment of this Honorable Court regarding that issue. Lordship may kindly refer this matter to produce the certified copy of the voter list. I will fresh apply and thereafter I will exhibit that documents before the learned tribunal. Lordship may kindly have. Lordship may kindly see para 20 of this judgment. Please read. Lordship, para 20. Para 20, Lordship. Fourth line I'm reading, Lordship. But the fact also remains that the petitioner cannot be faulted with for not submitting the correct voter list of 1966 and 1970 during the proceeding before the tribunal, as the petitioner was provided with defective voter list of 1966 and 1970 by the state authorities. These defective documents were not created by the petitioner. These were official documents which were provided by the state authorities to the petitioner. If the state authorities were maintaining and providing defective voter list, certainly the fault primarily lies with the authorities and the petitioner cannot be put to a disadvantageous position for the mistake committed by the authorities. Lordship may skip 2 lines, Lordship. Then, now that the petitioner has been able to procure the correct voter list of 1966 and 1970, a great injustice would be caused to the petitioner if the petitioner is not afforded an opportunity to submit the same to the tribunal for consideration of its opinion. Then Lordship may kindly come to last line, Lordship, of the same page. Citizenship in the modern state is perhaps the most important attribute of person, without which a person can hardly enjoy any of the rights conferred, protected, and guaranteed by the state. Apart from this, Lordship, my learned friend is insisting regarding shifting, Lordship. Shifting is uh, 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 explained in the written statement as well as evidence. In details, Lordship, it is explained, Lordship, how the petitioner was subjected to shifting, Lordship. Due to erosion of river, I have stated in my petition, due to erosion of river, they were subjected to shifting. And already my learned friend has referred to the Sirajul Haq judgment by the Honorable Supreme Court, Lordship, wherein it is stated that shifting cannot be a ground to disbelieve the documents, Lordship. That observation is there. Sirajul Haq judgment, Lordship. It is, Lordship, 2019 5 SCC 534. Lordship may kindly come to the last page, Lordship. Last page, before the last two para, further, the mere fact that the father may later have gone to another village is no reason to doubt his documents. So shifting cannot be a ground to disbelieve documents. Every person may have reasonable shifting, Lordship. And these are under compelling circumstances, they shifted to another village, nearby village. Matragula and Balasore is not too far, Lordship. Nearby villages. Lordship, regarding the anomalies, Lordship, I have stated in my written statement as well as evidence, Lordship. The Pathan Ali, Pathan Ali Khan, Pathan Khan, Jamiran Zariman, or are stated in written statement as well as evidence, Lordship. Those were not put to silence, nor the evidence was cross-examined, Lordship. So if the documents were not put to silence, if the evidence is not cross-examined, then authenticity cannot be denied, Lordship. There is another judgment of this honorable court, Abdul Khalik. Abdul Khalik judgment. That is also reported in 2015 1 JLT 947 perhaps. 2015 1 JLT 947.
See, basically, when you place a judgment, you have to read the context of the judgment and the facts of the judgment. First case that you have placed, regard to Kafatullah and Kamatullah, where their lordships have clarified that the father of the proceeding might have gone to another village, is not present to doubt this document. What was that document? That document had the name of the grandfather, father, his name, the members of the others of the family in that particular voter list. So, in one village where he was there, his name was Kafetullah. And when he went to the other village, his name has become Kamatullah. Now, this Kafetullah and Kamatullah in two different places. But name of the father of Kafetullah and Kamatullah is same. Other members that figured in the village A and village B, same. That is why in that backdrop, the court considered the fact that Kafetullah, whose name figured in one village as his father, and Kamatullah in another village, those shifted. The same because the names of the other persons in that particular list remain intact. Right? So that is the reason, and that the Honorable Apex Court have said that the shifting of the father to another village will not create any doubt because these set of names remain intact, excepting the name of the father, Kafetullah and Kamatullah. That is the background. Simply, the shifting is not the issue. Yes. Few things are there. Basically, under the Foreigners Act, as you have read the judgments, entire burden is on the proceeding. If proceeding relies upon the voter list, is in phases. That is why draft voter list is published, informing all concerned that some name is wrong, road is wrong, father's name is wrong, age is wrong. It needs to be corrected. Earlier applications was required to be filed, now it has become very complicated. You can go straight away, just website and do it. And that is why the first draft, second draft, and thereafter the final. Even after the publication of the final list, you will see another voter list comes out. In Assamese, Hongho Hito. Why? Why? That means even after the publication of the final voter list, some applications filed just prior to the publication of the final. Some people applies for correction and indemnify that cutoff date. They have to be published. So again, an amended voter list is issued. So it happens. If the proceeding wants to take the help of a voter list to establish his citizenship, then it is burden on him, not on the others. In this backdrop where the names are written only, it should have been ABCD, it is written ACBD. That's a different issue. But if it is in the name of ABCD, if it is written XYZ, the burden is on the proceeding. And that is why the Apex Court specifically meant first name, third name, fourth name, fifth name. The same, there is no mistakes in it. Only with the second name, Kafetullah and Kamatullah. In both the villages, they found the ABCD, first row, third row, fourth row, fifth row, all are intact. Except in the number 2, Kafetullah in one village and Kamatullah in the other village. Now your entire case is the name of your father is Matab Ali Khan. Name of your father, grandfather is Pathan Ali Khan. Right? Yes. Or Pathan Khan, whatever. In your written statement, you did not disclose name of your brother, sister-in-law, your mother, or the name of your wife. Without,
Those are their lordship, document wise, I have paragraphs, paragraph wise, I have
in your
stated.
written statement.
Lordship.
Now, if you have not stated something in your written statement, can you bring in those things by way of evidence?
Lordship is very correct.
See, we are here
Lordship,
only to find out those things.
lordship.
That is the reason we have to go by section 9
Yes, yes.
of the Foreigners Act. We have to go by the provisions of certiorari right. We have to see whether the decision given by the opinion rendered by the tribunal is right or wrong.
Yes.
If you have not stated anything in your written statement that such and such is my mother, such and such is my brother, such and such is my sister-in-law. Suddenly you have produced a voter list of a different village with many names, where it is Matab Ali Khan, grandfather name is Fasan Ali. Even in the 1985 voter list, after 1970, why, what happened after 1970? Where is the continuity? After 1970, you have kept the voter list of 1985, names are different. After 1985, you have come across a voter list of 97. What happened in between? What happened with the voter list of 1990? What happened with the voter list of 1995? These are the years when there were elections. What happened?
Actually, there is no such specific direction also there.
Why direction? It is
Yeah.
your case. That is the reason. It is the Foreigners Act which burden is on the proceeding.
Normally, the tribunal
See,
asks for,
see, whatever is in the material, whatever is the knowledge, it is on the knowledge of the proceeding,
yes,
not on the knowledge of the tribunal, not on the knowledge of the state. So it is, since it is in the knowledge of the proceeding, whatever is with the proceeding, proceeding have to place, even if there is no cross-examination of the particular document. You cannot jump from one name of somebody, A figured in the voter list of 1966, 1970, name of Mr. B figured in 1966, 1970, and in the year 1997, name of X, Y figured. So X and Y is the son of number B, whose name figured at 1966, 70. Can you go that way? There had to be continuity. Since whatever evidence is there, it is in the knowledge of the proceeding, it is the duty of the proceeding. That's why section 9. You read the objection reasons of section 9. Then you will clear why, what is the requirement, why the Honorable Apex Court has passed so many judgments with section 9. Because accepting the proceeding, nobody will have that knowledge. What is happening inside the family, only the proceeding will know. That is the reason why the enumerator, when it comes to correction of the voter list, when the proceeding, when the concerned person fails to place anything, he writes to the election officer. No documents placed. Right. So, and they have the voter list of previous years. When the enumerator comes to your house, or when a particular center is made for entering your name in the voter list, all the previous voter lists will be available. You only have to show that you have come from this place to this place. My name may be recorded. If you are coming from Bihar, if you are coming from West Bengal, then also you have to file an application. I have shifted from this to that. My name should now be included in this particular constitution. There are many people who are coming from Bihar, their names are incorporated here.
yes,
But if you do not file any application and you want to incorporate your name, definitely not.
okay.
These are the reasons it is
Okay.
available in the representation of the people. It goes together.
Lordship may kindly
And if you are
appreciate.
relying on a voter list, you have to rely, you cannot say this is wrong on the voter list, this is correct in the voter list.
Yes.
It is your evidence.
Lordship may kindly appreciate
After 1997, everything is in order, Lordship.
That is the
But
reason we are
before
asking
that,
you.
these people were not so conscious, Lordship. And-
In your written statement, you are totally silent about your family member. Sarvananda Sonowal is very clear, name of the parents, date of birth, place of birth, everything has to be given. Now,
Those are-
there is a name of your mother in the voter list or in your written statement. Which particular paragraph you have mentioned your name of your mother?
Yeah, Lordship. That is where paragraph was, their names are there, Lordship.
Why the prosecutor was supposed to feel shy to name his mother?
No, Lordship.
Because you always file documents after the filing of the written statement. By the time you can procure certain documents. One lady finally becomes a mother of yours.
Yes,
That
sir.
we have seen in most of the cases. It may not be, but most of the cases we found that mother's name will not be there, sister's name will not be there, brother's name will not be there.
Yes.
During the time of evidence, you'll procure certain document and you'll come. That's why
Right.
if there have been documents, you would have straight away you could have said before filing a written statement that she is my mother, she is my grandmother. What is the name of Matab Ali Khan? Who is the mother of Matab Ali Khan?
Matabali Khan.
You do not know.
Yes, Lordship.
You do not know as a counsel. Even the prosecutor doesn't know. Who is his grandmother?
Yes, Lordship.
That's why the Honorable Apex Court, while considering this, Sarvananda Sonowal considered all these aspects. Para 24 very clearly stated.
Yes, Lordship.
Why? What is the reason for that?
To some extent, para 24 is followed. Everything is not detailed.
See, everybody is silent, only showing the name of the father, no mother, nothing.
Everything is not given, Lordship. One or two, those are left, Lordship.
You know why.
Yes, sir.
We also know why, but legally,
Legally,
because the person concerned will not have any such documents, he has to rely upon to survive to become an Indian citizen. So he has to give some documents.
Lordship, my humble.
There is, see, there is no fear on your part. You know your parents,
Yes.
you know your grandparents, everything.
Lordship.
But those people,
Lordship.
you know very well.
They even forgets their son, who is a son, who is
Even
father.
will not remember how
Father's
many
mother
children
is
you will have.
They
right?
even, yes, Lordship. So, Lordship, my humble submission is there is no bar to remand the matter before the tribunal.
For what we have to remember?
Lordship, to establish all those things, Lordship.
Why
What your
now?
Lordship has stated.
That you can always could have approached the tribunal immediately after the order that you have said these documents could not be placed before during the proceeding, so it should be allowed you to.
Lordship, with that observation, Lordship, may kindly remand back the matter, this
Then
matter.
tell us.
Already, the Honorable High Court has remanded many cases, Lordship, in this.
Might
matter.
have. Have you a recent judgment of the Apex Court with regard to the certiorari which it was placed by Mr. Pine day before yesterday?
Lordship, may other things may kindly be
See,
appreciated, Lordship.
normally what happened, at times we have seen, while exercising the power of certiorari, we have extended to a different line. And for that reason, it's not that it's happening here, it's happening everywhere. That's the reason the Apex Court and lastly specifically made it clear, even if the order is wrong. To that extent, the Honorable Apex Court, even if the order is wrong, the High Court will not interfere in exercising the power under certiorari.
But Lordship,
Read that judgment and tell us
Lordship is hearing the matter under 226, Lordship. Ample power is there, Lordship.
that is you're wrong.
Ample power.
That is where you are wrong. We are not hearing it under 226
Okay.
alone. We are hearing specifically under the exercising of jurisdiction under certiorari.
Uh,
226, as you know,
Lordship.
mandamus, quar into habeas corpus and many other things, right?
Lordship.
So we are exercising the power only under certiorari. And read that judgment of certiorari. Then you tell us, yes, whether we could have passed any such order, setting aside the order of the learned tribunal or upholding the order of the tribunal.
Otherwise,
If you want, go through that particular judgment and come back to us.
Lordship, that
Thereafter, you tell us. That is the reason, while exercising the power under 226, that is why I'm saying we have deviated from the certiorari. That's the law. We cannot go beyond that. Even in Muslim Mandal, it is there. Now it has been reiterated by this particular judgment.
Say no, no.
Give him the citation, let him go
Yes.
through,
2023 SCC online 996.
give the party's name.
Yes,
2023
Three,
SCC
SCC online
online,
SC 996,
SC 996.
Central Council for Research in Ayurvedic Science and others. Another
So
aspect,
Mr. Hussain, remember one thing, definitely this is a 226, but not under mandamus or warrant or anything. This is statutory. It will just long back. You should have heard her father, she is sitting behind Justice D.N. Chaudhary. He was a master. He was a teacher of law. He used to teach law. You should have listened to him. In some of the judgments, he has clarified the powers of the writ. Read those judgments, you'll know. We cannot deviate from certiorari to any other things. And his lordship has rendered those judgments. Read those laws, those judgments, then you will know the difference. You are right, in some judgments we have seen, you have placed, but we cannot, that is why I am asking you to go through this recent judgment and tell us whether we can.
I will prepare on
We'll have
this.
it Tuesday. Next Tuesday.
Lordship. Match. Lordship.
We'll have it on Tuesday.
Tuesday on 21st. 20.
You come back and tell us after reading the judgment.
Lordship.
Not in person. Yes,
Several days were given for you to file the document.
notice was given to you. When? Hmm. You received the notice on 29th, right? You did not appear. Second notice was issued on 22nd of August 2017. You have received. Then you, for the first time, you appeared before the tribunal on 1st of September 2017. You can note down. You took time on 22nd of September 2017, 11th of October 2017, 25th of October 2017, 10th of October 2017, then 21st of November 2017, when on 21/11/2017, tribunal said if you do not file a written statement, the order will be passed ex parte. Then again on 1st/12/2017, further time was granted to you by the tribunal. Then on 7/12/2017, you filed your written statement without any documents. Then 16/12/2017, again time granted for documents. 27/12/2017, time granted for documents. 17th of January, time granted for documents. 18th of January, time granted for documents, specifying that if you do not file it on the next date, orders will be passed. And it was on 18th of January, the last chance granted to you. And matter was fixed on 24th of January. Ultimately, even on 24th, you did not submit any document. And on 24th of January, the tribunal passed the order. Where is the illegality? Hmm? Is there any illegality in the order? Want to show any illegality in the order passed by the tribunal? Tell us on the basis of those documents whether the order of the tribunal, the opinion of the tribunal is bad or good or what. You have any other document to place before the tribunal or which you want to place it before the court? Only is those three documents that was. Hmm. Now just tell us one thing. Land document. Was in the name of whom? Hmm. How you have proved that? Muhammad Maulavi and Basir Sheikh is the same in one person. Where from you have seen it? You have to prove it, right? Where from you have proved that? Read your written statement. Read your written statement. Hmm. Hmm. Then okay. Now please come to your document which you have annexed. You are relying on this particular document, right? Hmm. Yes. Hmm. Hmm. Can you tell us where is this land? Where is this land? Hmm. One Muhammad Maulavi, whose father name was Kinu Mullah, was from village Senikwa. Right. And he was a royalty of government land. Where? In which place? At which place? Tell us. If you see at the top at page 16, you will see it was at South Salmara. Village, it is at under Sapper Revenue Circle. And the village was Dihi Ghanimari. Now, according to you, as per your written statement, Muhammad Maulavi and Basir Sheikh is the same and one person. Now, this land we have seen at Sapper Revenue Circle, South Salmara subdivision, at village Dihi Ghanimari. And that Muhammad Maulavi, alias Basir Sheikh, was from village Senikwa. Right? Now come to the voter list, page 18. Your father, Fazar Ali, son of Basir Sheikh. Right? And this is of which village? Village is 216 Kullanpur. Nothing to do with South Salmara, nothing to do with Senikwa, nothing to do with Sapor. You shifted. It is not your case that your grandfather or your father have shifted somewhere. So if it is Maulavi, Muhammad Maulavi and Basir Sheikh have to be the same person, then he should have been at Kullanpur, at village. It is not your case that your father has shifted from Senikwa to this Kullanpur. Question of assumption will not be there, it has to be evidence. Where is this evidence? Relying on these three documents. You have said it, later on for your this thing, you have shifted to Sidli. So at Nepalpara, you are residing under Sidli police station. So your name figured in the voter list of 1997. When you have shifted to Sidli? That will be only in the knowledge of the proceeding. As a council, you will not know. The other authorities will not know. So, now, when can an Ali become Munsi? When can an Ali become Munsi? You are Mr. R. Karim. When Mr. Karim can become Munsi? Is it possible? You can change your title by filing an affidavit, publishing in the newspaper, right? Otherwise, anyway, we are not on that. You have seen 3 different villages. There is no mention in your written statement that though your grandfather was in village Senikwa, but your parents have shifted from Senikwa to Kalyanpur. Is there any mention? There is a mention that you have shifted to village Nepalpur. But what about your father? What about your grandfather? You know the outcome. Now, what is the illegality when the tribunal have said that procedure failed to adduce evidence, discharge the burden of proving him is not a foreigner? Wrong or correct? Who is wrong? Who is incorrect? Not why you should be. Mr. Karim is not at fault. It is the duty of the proceeding to place the relevant documents before the tribunal. The proceeding failed to place any material. It is not that the tribunal did not give ample of chances. You have seen, in spite of receipt of notice, initially the proceeding did not appear. Right? So you know the outcome. You want to add some salt or some sour or some sweet in it, Mr. Payeng? Difficulty is,
Yes.
proceedings. They are
Proceeding.
mostly illiterate. They will not have the documents.
Hmm.
But the worst part is they will have the voter list.
Yes, my lord, if first of all, the tribunal has recorded, my lord, with regard to exhibit 1, that the date could not be ascertained. Exhibit 1 is land record in respect of 1B, that is page 12, my lord. In the opinion, last period, 1 acre of government acquired land, wherein the name of one Molobi, son of plate Kinu Mudla village, Senaki stands record as the riot without possessory right, with illegible date and other information.
We will not go to that extent.
Yes, I don't know, my.
Even if you see that particular document as annexes, it has been annexed
Yes,
here.
yes.
It is very clear that
Which-
Molobi
Yes,
was from village
the
Sinikhwa.
person is from Senikwa. The land recorded is in South Salmora, it is Dihi Kunimari of South Salmora and
Under
He don't-
supper subdivision.
yes, and he don't have possessory right over the land.
That's there.
That's
Police
there.
Auto is there.
Yes. So that is the first document. And the second documents, my lord, in fact, second documents, if we accept the second documents, it is start from 1979 on.
That's
Even
post
though.
71.
Yes, post 71. Even
But there
though
is
we.
no document to show
That.
Basir Sheikh and the
Yes,
Muhammad Molobi is the
Hazar
same
Ali.
person.
Hazar Ali was there prior to 71, because if he could establish at least this Hazar Ali was there prior to 1971, that
Then
could have been
also.
it, then also, my lord. But Hazar Ali prior to 71 was one is not there. On the 79 voter list, it is the first documents and it is a post 71 document. And second one issue, my lord, he projected Esaran Nessa as his mother. The tribunal has rightly pointed out
26 and 21.
26 and 21. So how can it be? It's a projected one, madam. And shifting, he has no, from one village to another, 3 villages, madam. From grandfather to father and the petitioner. When these documents were submitted but not proved, no evidence to that effect to prove the contents of the documents, my lord. Even though it is certified, even if it is certified copy, my lord, he has to prove the bring the, because these are Xerox copy of the certified, and he has to prove this by bringing the original and comparing the original.
Where is that judgment? You have said there is a judgment.
My
That
lord,
it has to be, voter list has to be. In some of the cases, the authorities have brought before the court by the proceedings to adduce evidence.
Yes, my lord.
And on that basis, but here, there is a judgment, you said.
No,
in
that,
regard.
my lord, here in this case, what my submission is that even though it is, my lord, certified copy, if we accept the certified copy also,
Then also,
my lord, certified copy, there, he has to bring the original of the certified copy. That is not compared. And it has to be compared before the tribunal by saying that this is the certified copy and I have submitted the photocopy. So then it is said to be proved in original, but it is not proved. The documents are not proved. And second contention, my lord, yes, your lordship, the second contention was that even though it is proved, in some cases, because I produced the judgment, this honorable court has said, as because there are cases, my lord, reported cases that, my lord, the anomalies, there are some false documents are available in the state of Assam. So it is in public domain. So in the state of Assam, the tribunal, while seeing these documents, has to insist for the, my lord, the proof the original by calling the writer of the documents. That's how I'll produce the
okay.
The part is the Mr. Karim has no information as to whether they have appeared before the
Yes, yes.
board.
To that effect, I will get an information,
No,
my
no, no,
lord.
he was arrested and was released on record. He was arrested and he was released on bail. That much is there in the record.
Yes, and now whether, my lord, before, your lordship may pass the order, but in the meantime, I will get whereabout this person is. Because my learned friend also don't have the information.
Yes. Thank you.
Heard Mr. R. Karim, learned counsel appearing for the petitioner. MS J. Sharma, learned CGC for the respondent number 1. Mr. J. Pine, standing counsel, Home Department, Assam, for the respondent number 2. And 6. Mr. A.I. Ali, standing counsel, Election Commission of India, for the number 3. And Mr. Hazarika, Government Advocate Assam, for the respondent number 7. Here is the record. List this matter on 30/11/2023 for necessary order. This order will be in the name of my sister. Huh? There will be single bench. Both myself and my sister will single.
Well, item number 456, my lord. This is a different matter, my lord. In this case, grade pay challenge, my lord. LP school teachers reducing some challenge. Lordship, division bench, this honorable division bench has to hear the matter. Yes, my lord. So matter may fix on another date, my lord. Already lordship heard it, and earlier occasion it was, my lord. Our petition was allowed.
Who was there in the other side?
Finance, I will inform, my lord. Buddha was here, my lord. Actually, in the morning time here. Yes, so
Mongolbury, where? Tuesday, 21st.
My lord, item number 7 may be fixed on 5th of December.
Make a mention then.
Application. He was granted interim bail and he accordingly, as per my instruction, appeared before
But
the.
he has appeared, my lord.
Regarding the merit of case, perhaps your lordship remembers, my lord, there is a case regarding theft of some supari from the godown, my lord, which is to be auctioned, my lord. And thereafter,
It was missing.
it was
What is-
all the,
now,
all
what is
the,
finding?
all the, my lord,
He appeared, his statement recorded.
he has appeared, my, he was two, okay, accomplices, the one is from
One is to state
Bangalore,
Bangalore.
yes,
They
that
had
part,
Scorpio
yes, sir,
vehicle or
yes, sir,
something.
that,
Yes,
that case, my lord.
Now,
Now-
Mr. Goswami, just tell us one thing, whether his father, whether his custodial detention is required.
My lord, that, my lord, otherwise, my lord, he, all his, my lord, as per the, my lord, version of the other accused who were arrested, my lord, that he is the main person and he has more share, my lord, and others are only, my lord, his accomplice, my lord. He is the person behind the, my lord. So
When did he appear before the Ayog?
he appeared, my lord, on 26/10, and an adverse report also given, my lord, after his appearance, that though, my lord, he appeared, there is sufficient evidence, so I am involved in the case, so I am going to arrest him in this connection, manner. Return arrested and given bail, manner. So since, my lord, his materials are there against this petitioner, my lord, such is not yet, because the case is pending for, my lord, as per the last entry, my lord, for recovery and, my lord, arrest of, my lord, other 4 persons, my lord, who were on the absconding, my lord. And from the, on, not only from, my lord, one petitioner, my lord, who is with him in Bangalore, my lord, there are other instances, my lord, who also stated that, my lord, along with him, my lord, he is the main person, my lord, witnesses of other accused.
Or Mr. A. Ahmed, counsel appearing for the petition. And Mr. M.P. Goswami, learned additional public prosecutor Assam. By this application under section 438 CRPC, the petitioner, namely Tipu Sultan Khan, son of Akhtaruddin Khan, prayed for his pre-arrest bail in Ramnathpur, police station, case number 52/2023, registered under sections 457/380 IPC. Earlier, petitioner approached this court for his pre-arrest bail
Twice, my lord.
in said Ramnathpur PS case number 52/2023 in AB number 1736/2023, as well as AB number 2137/2023, respectively. And a court by orders dated 30/05/2023 and 20/07/2023 rejected the pre-arrest bail prayer of the petitioner, referred by him in those AB numbers noted above. However, on 19/10/2023, the court granted interim bail to the petitioner named above in said Ramnathpur PS case number 52/2023. Mr. Goswami, learned additional public prosecutor Assam, from the case that is submitted, the petitioner appeared before the concerned investigating officer of Ramnathpur PS case number 52/2023 on 26/10/2023, wherein he was arrested and was released on bail pursuant to the earlier order, pursuant to the interim order dated 19/10/2023. Matter relates to seizure of 530 numbers of bags of foreign origin betel nuts.
Not seizure, madam. Yes, madam, seizure,
Seizure,
yes,
seizure.
yes, madam, first it is seizure, madam.
530 numbers of bags of foreign original betel nuts from two wagons of Bhairavi BHAI Silchar passenger train at Bhairavi railway
Petition,
station
petition.
weighing about 37,
Petition, petition.
100 kgs.
Yo.
Those seized betel nuts were kept at Baldi Community Hall, BLDI, at Zamira. By locking and sealing the said hall that is under the jurisdiction of Ramnathpur Police Station. With regard to such seizure of 37,100 kgs of foreign origin betel nuts in 530 numbers of bags from Bhairavi Silchar passenger train. Badarpur GRPS case number 33/2022 under sections 120 within bracket P/420/471/413/34 IPCR was already registered. When the authorities went to auction the seized betel nuts kept in said Baldabaldi Community Hall at Jamira, and the lock and key, on 03/04/2023, the authorities found that out of 510 numbers of bags of those betel nuts kept in the said community hall were found missing / stolen. And accordingly, Ramnathpur PS case number 52/2023 was registered. Mr. Goswami, learned additional public prosecutor submitted that the co-accused arrested in the case have already implicated the petitioner. However, it is found that there is no such submission on part of the concerned investigating officer that the petitioner violated the conditions of interim bail, or that he did not cooperate with the investigation of said Ramnathpur PS case number 52/2020. Considering the same, the interim bail granted to the petitioner earlier on 19/10/2023 in said Ramnathpur PS case number 52/2023 is thereby made absolute. However, the petitioner shall comply with the terms and conditions of the order dated 19/10/2023 passed earlier in this process. And further, shall cooperate in the investigation of said Ramnathpur PS case number. Failure on the part of the petitioner to comply with any of the terms and conditions specified in the order dated 19/10/2023. And if the petitioner is found not cooperating with the investigation, it is made clear that the bail granted to the petitioner in such shall stand automatically. In such circumstances, the investigating officer of Ramnathpur Theatres shall be at liberty to file application for cancellation of bail to the petition.